most awaited. Can I now request Dr. B.V.Acharya to tell us in his own words?
The Chief Justice, Justice P.B. Varale, President of the function, Shri Uday Holla, Shri Veerappa Moily, and all other dignitaries on the dais, respected Justice N. Santosh Hegde, all the learned judges, sitting judges from the High Court, and Justice Anand Bera Reddy, former judge of the High Court of Karnataka, for whom I have great admiration. I am very happy to see him here today. Then Sri Prabhuling Namadgi, former Advocate General, Sri Kantaraj, all the senior advocates, my advocate friends, respected invitees, ladies and gentlemen. In the last 1.5 hours, you have heard everybody was praising me for so many things. I was very happy, naturally. But today I am happier still because all this praise was in the immediate presence of my wife. Therefore, it has given me a lot of satisfaction. First of all, I would like to sincerely thank Vakeela Vahini entire team, and in particular Sri Prashant Chandra and Dr. D.M. Hegde, who have taken so much pain to arrange this function in such a grand manner. I am very grateful to you. One great thing about this function is Vakeela Vahini has been able to get together so many great personalities in the field of law, almost all in the state, and they are led by none other than the Honorable Chief Justice, that is the head of the judiciary in the state. Therefore, it's a matter of great pleasure for me. Please see Justice N. Santosh Hegde and all the judges of the High Court have all attended the function. Justice A.V. Chandrasekhar also. And then the other dignitaries on the diet, the learned Advocate General, who represents the state, Sri Vivek Subbareddy, President of the biggest bar association in the whole country, Bangalore Advocates Association, and Sri Veerappa Moily, a rare personality who was the state law minister, who was the union law minister, and above all, a great literary figure, not only as a lawyer, but a literary figure who got even the Saraswati Award for the famous epic which he has written. And now, as he said very shortly, the book will be published, Bharatiya Nyaya Shastra, containing about 500 and odd pages. I am glad that the Honorable Chief Justice is here, not only as a Chief Justice, generally the State Chief Justice is from outside the state. But to our luck, we have a Chief Justice who has openly, other day in the International Lawyers Convention, he declared, I am not only the son of Karnataka because he was born in Nippani in Karnataka, but I am also the son-in-law of Karnataka because I have married the daughter of Sri K.H. Ranganath, who, it's a coincidence, was a cabinet minister in the ministry of Sri Veerappa Moily. Therefore, the presence of our Chief Justice is a matter of great significance for me. So far as Sri Veerappa Moily is concerned, as he said, our association is for more than 55 years. In fact, exactly it is in 1968, he took me to Karkala to appear in a case on behalf of a tenant. I and Sri Moily together appeared in that case, and in those days and even thereafter, he was appearing only for the tenants, and we conducted the case. Thereafter, our association was continuous. Actually, we were family friends, and it was my luck that when he became the law minister, in the very first cabinet meeting, usually the first item is appointment of Advocate General, and they usually say, we leave it to the Chief Minister. But in this particular case, it so happened, I am told, Sri Virendra Patil straightaway said, we will leave it to the Law Minister. And then I got a telephone call from Sri Moily when I was in Bangalore. That is how our association started. He appointed me. And after 1 year, the ministry fell and I resigned. 2 years later, he himself became the Chief Minister, and even without consulting me, he appointed me as the Advocate General. Of course, I was not opposed to the idea, but he did not even consult me and appointed me as the. And after that, when he became the Law Minister, Union Law Minister, he offered me the post of Additional Solicitor General of India for South, and he even offered to shift the headquarters from Madras to here. But for my personal reasons, I declined the offer. Then he appointed me as the member of the Law Commission of India, and I was the first Kannadiga to be appointed to that post. Thus our association continued. He was my famous client, I could say, in so many matters, and it's a matter of great satisfaction for me that today he is one of the speakers here. In fact, 6 years back, on completing 60 years, when there was a function to felicitate me, and Justice M.N.V.J. was he presided, and Justice L. Nageshwar Rao was the chief guest, and also Sri Vishwanath Shetty was the chief guest. He was the then Lokayukta. Sri Veerappa Moily, having come and sat there in the morning, by 10:15, he was there till the entire function was over, and we had lunch together. Just like that, today I was surprised that Justice Santosh Hegde has come, but he declined to come to the dais. And so far as A.V. Chandrasekhar, he has already said I appeared before him both when he was a district judge and also before the High Court. And one thing I could tell you is that he is responsible for saving so many families and so many houses as chairman of the committee appointed by the Supreme Court with regard to the Shivaram Karan layout. So many people with hard-earned money had built houses. They were all to be demolished according to the first direction of the Supreme Court, and as a chairman of the committee, he has saved many people. That should be told to his credit. So far as Sri Harnalli is concerned, not only he was my junior, as he stated, when I was the Advocate General for 2 years, he was the Law Minister. We had such a close relationship, and I will never forget that. And so far as Vivek Subbareddy is concerned, as I already told you, I consider it that the entire bar of Bangalore has come and he is representing them. Thus, this way, all the judges and lawyers, everybody in the legal field in this state have come, and you have come here to bless me. That is how I will take it. Now, one thing that I would like to say, please don't think that I will be lengthy, because even as a lawyer, all judges will vouchsafe that I am very brief and to the point. So I will not take much time, because we have heard so many things. One important thing that I want to say is that I am an ordinary person. I was an ordinary student, and I do not claim to be a brilliant lawyer out of the ordinary. My only asset is my experience for the last 66 years. And as is well known, it is the duty of everyone, one who has got some knowledge, to pass it on to the next generation, just like Sri Vivek Subbareddy said. That way, it is the duty of every senior. Whatever knowledge and experience he gains, he should pass it on to the juniors, so that the new generation will have the benefit of that. That way, I am confident that I have passed on whatever knowledge and experience I had to all my juniors. There are not many, but almost everyone who has been with me, they have all reached very high positions in life, and that is a matter of great satisfaction for me. Not only those who have been in my chambers, there are many, but those law officers with me when I was the Advocate General, with whom I have worked, they have all come up very well in life, and many of them have become High Court judges, and 3 of them have become Chief Justices of the High Courts, and at least one of them became the Chief Justice of India. That is the contribution I can claim. No doubt they have come up on their own, but I am proud that they have been with us. And now only 2 points I want to say. One important thing I am requesting is, this is my appeal to the members of the bar. That is, as you know, the problem of arrears is there, and it is so acute that it is very difficult to find a easy solution for it. But one request I am making to the lawyers is, as far as possible, please encourage settlement of disputes, either out of court or by mediation or conciliation, and if that also fails, at least arbitration, so that the burden on the court is reduced. This is one appeal. Second, one small thing I want to say is, generally there is an impression that the lawyers go on taking adjournments Therefore, there is arrears. This is not correct. No, there may be fault on the part of the lawyers. I will not disown it, we will own it. But what happens? 50 cases are posted before a judge. Now, first few cases, witnesses are present, old cases. They are kept by. Thereafter, there is no point in making the lawyers and the litigant witnesses to wait till evening. So what happens? After some cases are taken up and kept by, the remaining cases are adjourned. But the client goes thinking, because my lawyer sought adjournment, it is, after all, granting or not granting adjournment is in the hands of the judge, and it depends on the judge. And we know before whom we could seek adjournment and before whom we should not. Before Justice Shastri, no lawyer will go and pray for adjournment because he knows that it will not be granted unless it is so. It is not proper to blame the judges. But the real problem is vacancies. You all know, at no time the courts have worked in full strength. In our India, the sanctioned strength itself is far below the actual requirement of law. But even those sanctioned posts, they are not filled up. Now, for the first time, the Supreme Court, it is full. But in the case of even high courts, 1,140 is the sanctioned strength, but the total working strength has never gone beyond 700. Even day before yesterday, the law minister gave a statement in the parliament where he says there are more than 300 vacancies, and out of that some 80 are with the government, from 40 are with the Supreme Court Collegium, and the remaining 300, there have not been proposals from the High Court also. So, filling all the vacancies is absolutely necessary because the judges are overburdened with work. And secondly, you must appoint judges, competent judges. By competent judges, I don't mean that they must be PhD or able to know the House of Lords cases or foreign cases, but they must be able to decide and deliver the judgment. After all, the client is bothered about the decision in the case, and we don't know, we are writing lengthy judgments, a practice which we have. And another is, some judges have a tendency to convince the lawyers. That is totally wrong. A judge can ask for clarification, but if you try to convince the lawyer, no lawyer will get convinced because he is paid not to be convinced. He can't say, my client is wrong. Therefore, these are some of the small tips. In fact, I think Justice A.B. Chandrasekhar would have been an ideal judge to give some training as to how they should behave. He has, I can say without fear of contradiction, that he is one of the judges who dealt with and disposed of maximum number of cases every day. That is how you should do it. ಈ ವಕೀಲರ ವಾಹಿನಿಯವರು ಒಂದು ಇಂಟರ್ವ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಹೇಳೋದಿದ್ರೆ ನನ್ನನ್ನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. ಇವರು ಪ್ರಶಾಂತ್ ಚಂದ್ರ ಅವರು ಮತ್ತು ಹೆಗ್ಡೆ ಅವರು ಭಾಳ ಲೆಂದಿ. ಅದನ್ನೆಲ್ಲ ನಾನು ಹೆಚ್ಚಿಗೆ ಹೇಳುವುದಿಲ್ಲ, ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ ಎಲ್ಲ ವಿಷಯದ ಬಗ್ಗೆ ಕ್ವಶನ್ ಮಾಡಿದ್ದಾರೆ, ನಾನು ಆನ್ಸರ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಅದೆಲ್ಲ ಇದರಲ್ಲಿದೆ. ಇವತ್ತಿಗೆ ಎಲ್ರಿಗೂ ಇದರದ್ದು ಒಂದು ಕಾಪಿ ಕೊಡ್ತಾರಂತ. ಹಾಗಾಗಿ ನಾನು ಯಾವುದನ್ನು ಹೆಚ್ಚು ಮಾತಾಡಿ ಹೋಗುವುದಿಲ್ಲ. ಎರಡೇ ವಿಷಯ ಹೇಳ್ತೇನೆ. ಕ್ವಶನ್ ಕೇಳೋದ್ರಲ್ಲೇ ಇಡೀ ಒಂದು ಕ್ವಶನ್ ಕೇಳಿದರು, ನೀವು 66 ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಆಯಿತು, ಈಗ ಇನ್ನು ಪ್ರಾಕ್ಟೀಸ್ ಬಿಡ್ತೀರ ಅಂತ. ನಾನು ಹೇಳಿದೆ ನಾನು ಬಿಡೋದಿಲ್ಲ, ಆದರೆ ಅದುವೇ ಬಿಡ್ತಾ ಉಂಟು ಅಂತ ಹೇಳಿದೆ. ಇನ್ನೊಂದು ಕೇಳಿದರು, ನಿಮ್ಮದು ಅರೇಂಜ್ಡ್ ಮ್ಯಾರೇಜಾ ಅಲ್ಲ ಲವ್ ಮ್ಯಾರೇಜಾ ಅಂತ. ನಾನು ಹೇಳಿದೆ ಎರಡು ಸಹ. ಯಾಕೆಂದರೆ ನನ್ನ ಪೇರೆಂಟ್ಸ್ ಅರೇಂಜ್ ಮಾಡಿದ್ದು, ನನ್ನ ಒಪ್ಪಿಗೆ ಇದ್ದು. ಆದರೆ ನಾನು ನನ್ನ ಹೆಂಡತಿಯನ್ನು ಲವ್ ಮಾಡಲಿಕ್ಕೆ ಶುರು ಮಾಡಿದ್ದು ಮದುವೆ ಆದಮೇಲೆ. ಬಿಕಾಸ್ ದೇ ಸೇ ವೆಸ್ಟರ್ನ್ ಕಲ್ಚರ್ ಈಸ್ ದೇ ಲವ್ ಆ್ಯಂಡ್ ಮ್ಯಾರಿ, ಬಟ್ ವಿ ಮ್ಯಾರಿ ಆ್ಯಂಡ್ ದೆನ್ ಲವ್ ಅಂತ ಹೇಳಿದೆ. ಹಾಗಾಗಿ ನಾನು ಮತ್ತೊಮ್ಮೆ ನಮ್ಮ ವಕೀಲರ ವಾಹಿನಿಯ ಎಲ್ರಿಗೂ ನನ್ನ ಧನ್ಯವಾದಗಳನ್ನು ಹೇಳ್ತಾ, ತಮಗೂ ಎಲ್ರಿಗೂ ದೇವರು ಒಳ್ಳೆಯದನ್ನು ಮಾಡಲಿ ಅಂತ ದೇವರಲ್ಲೇ ಹರಕೆ ಮಾಡಿ ಎಲ್ರಿಗೂ ಶುಭವಾಗಲಿ ಅಂತ